Joe, can you hear me?
Yes, I can.
Okay. So I've got 11:59. We've got a few people already attending.
All right, we'll wait one more minute and then we'll get started. All right, I'm already seeing noon, so I think it's about time we go ahead and get started. Thank you for joining us on our trying to start a weekly webinar series about risk and compliance. Next, we already have one for next week, which we'll go over later. Just so you know, we have all of the forms that we're going to be talking about throughout this webinar in the handout section, so feel free to download those, as well as if there are any questions throughout the webinar, please use the chat feature and we'll get to those at the end. We don't think this will go the full 30 minutes, but it might, and we'll try to leave some room for some questions. So today's topics are going to be about reproductive health information. There's been some big updates from the government as to enhancing the privacy and security around reproductive health. We're going to give updates on the Change Healthcare breach, which has affected so many offices around the country, costing the health sector lots and lots of money. So there has been a huge push to, this is kind of an ignition to making some big changes in the healthcare privacy and security space. And then the last one we're going to talk about is keeping your doctor out of HIPAA jail. And this doesn't mean HIPAA jail, this means real jail. The Department of Justice has been kind of creeping their way into HIPAA rules, and we're going to talk about some cases that are affecting doctors right now and reminders of what we need to be doing to stay safe. So with that, I will turn it over to Michael.
Okay, let me take a second here to change the presenter. Okay, thank you and welcome everyone. We're going to go over a new rule put out by the Office for Civil Rights, and let me catch up my slides here. It's on reproductive health information. And you may be thinking, well, I can tune out of this because we don't have reproductive health information. We're not a OBGYN office. But this will apply really to every practice and something new to also business associates. So the new rule by the Office for Civil Rights states that reproductive health care includes health care that affects the health of an individual in all matters relating to the reproductive system and its functions and processes. The rule is to be interpreted broadly, so broadly that it could even include over-the-counter medications or devices. The fact that the patients had a mammogram is a reproductive health information. Over-the-counter birth control pills. If you are getting ready to send them for a radiology exam and you ask for if the patient is pregnant. So all practices will have to deal with this. Now, as we're going to go through in here, it's not something that's going to be an everyday occurrence, but when you receive these requests, you do have to know how to handle them. So this is a role or a purpose-based prohibition. So when it comes to this reproductive health care information, again, broadly defined, then you must ensure that the information being requested is not to conduct a criminal, civil, or administrative investigation into a person for the mere act of seeking, providing, or facilitating reproductive health care. And it cannot be to identify any person for the above purposes. So again, what this law requires is that there are now prohibited purposes of use for reproductive health information, and in certain circumstances, you will have to get a signed attestation by the person requesting that. So again, the prohibited purposes, again, are to conduct a criminal, civil, or administrative investigation for the mere act of seeking lawful reproductive health care. Now, that's kind of one of the key words there is, how do you know whether or not the reproductive health care was lawful? So that's kind of ambiguous. And again, you may need to get your attorneys involved, or to impose criminal, civil, or administrative liability on the person, again, for facilitating lawful reproductive health care, or to identify any person for the above. So, so how do you know whether or not this is going to be something that you have to do? So the changes are going to be here that you are going to have to ask for an attestation if it is for a health oversight activity, whether it is for judicial or administrative proceedings, law enforcement, or from a coroner or medical examiner's office. The good news it is not required for continuity of care, which of course are your main reasons that people request patient information. And I kind of have my slides out of order here, so I'm going to kind of come back here. So to implement this in your office, one, the rule requires that we update your notice of privacy practices. There are other updates from another rule updating the substance abuse disorder information. So for our clients, we will be, by the end of the year when this is required to be in place, we will have that updated notice of privacy practices with all of the different rules that are going to require changes to that notice of privacy practices. This rule is different from other rules in that typically business associates do not fall under the privacy rule other than what's in your business associate agreement. With this rule, the Office for Civil Rights specifically named business associates as having to comply with this rule as well. So that means that you're going to have to update your business associate agreements. What I think is the hardest part of HIPAA is keeping these agreements into place. All of them are going to have to be updated and re-signed so that this information is included in your BAAs. And of course, you're going to have to train your staff, specifically your medical records department, on what is reproductive health care, how do we address it, how much do we need to review it before releasing it, and again, when is that attestation form going to be required? So other documents that are going to require updating in addition to the notice of privacy practices and business associate agreements are, one, your policies and procedures. They're going to have to be updated for this new rule as well. They're going to have to be familiar with, and you're going to have to implement into your office the attestation form. We do have it in the document section so that you can download that today. And this rule also affects information blocking. Now, information blocking, as we did in our seminar last week, or webinar, you have the enforcement rule is in place, and so you need to make sure that your information blocking rules, regulations, and training to your staff are updated for these new rules as well. Again, for the most part, I don't think this is going to have a major impact on your practice, but again, we need to be aware of it, and you need to implement where it is needed and required. So here's the big question, because the rule from the Office for Civil Rights states that if you get a court order signed by a judge, you may not be able to release that information based on this new rule. So you're going to be defying a judge's court order. And also think about all the subpoenas you get. Are you going to have a trained person or send them to your attorney to inspect them to ensure that they are not being used for a prohibited purpose? So I think that would be very costly and very difficult. So we think that you should implement a standard policy for all subpoenas and court orders that an attestation is required. That's the easy way to protect yourself. From our experience, these don't come in that often. Well, court subpoenas do. And getting the attorneys used to signing this attestation before release. Now, I told you this rule is very broad. I would get it for both males and females. That the rule has been interpreted by some attorney practices as even including male reproductive health information. So for all court subpoenas, I would require an attestation just to make it simplified for your medical records department and to make sure we comply with the law. So one of the things that is recommended is that you do an identification of all the reproductive health information in your office. So this is the attestation form. Again, the instructions and the form are available for download. If you're watching this webinar, please send us an email. We'd be happy to send this to you as well. But again, Holland and Knight issued this potential legal issue that, again, you could get a subpoena or court order and have to make a legal determination whether or not to release the information. We are not attorneys, and so we definitely recommend, if you have questions, that you refer to your attorney with these type of issues. So I've got the Holland and Knight insight there, and the full information to go to the full article that they did on this subject down there as well. Okay, so I'm not seeing any questions come in yet or anything in the chat, but if you do have anything, please document those in there. Again, for most practices, this is going to be a minimal requirement to get this implemented into our office, but we do need to make sure that all of our documentation is up to date and our staff is properly trained. So now I want to go to the Change Healthcare breach. So many of you have called us and asked us about this, and so we want to basically go over. Now, a couple of our practices changed EMRs last year. They went from or changed their clearinghouse, and they were using Change Healthcare, but now they're on another clearinghouse. So that doesn't mean you're out of this, because your patient's information was more than likely involved in that Change Healthcare breach. Now, Change just announced about 20 days ago or so that it's actually a HIPAA breach. They kind of put it out there that it was a security incident, but they had not formally declared a HIPAA breach. Big reason for that is because then they had 60 days to get patient letters out. Now, they have taken full responsibility. They are going to take care of your breach notification requirements. And I want to emphasize that. Change Healthcare is your business associate. And therefore, they could have said, we're just going to notify you of the patients affected and have you send out all the letters with identity theft protection and the like. They're not doing that. They're doing that for you. That doesn't mean that you are free and clear, though. Now, the first thing I want to put on here, though, is that I want to use this instance to stress the importance of that business associate agreement. Luckily, Change Healthcare embeds it in their agreement, so I know you have it. But with your other business associates, if this had happened and you didn't have that business associate agreement, you could face a $100,000 fine or a six-figure or even a seven-figure fine just for not having that agreement in place. So this is a great example of why you need to implement and make sure you've got a valid list of all your business associates and that you have signed agreements with them. And again, we're preparing the new updated risk analysis, business associate agreement that you are going to have to get re-signed by all your business associates. We're going to add an addendum because they are difficult to get. So we're going to just add an addendum so you can either go with the full new BAA, which will have other things in it as well, or just the addendum requirements there for the reproductive health information. But getting back to your responsibilities, first, make sure you have a business associate agreement in place. But two, you at some point are going to want to get a list from Change Healthcare of all the potential patients that were affected by the breach, with some documentation showing that they were sent breach notification letters. I don't think that they're going to be able to accomplish that for years. We'll see. It took them quite a while just to acknowledge the breach. And now by the time they do all the forensics, that's not going to be top on their priority list. But at some point, you will want to get that. Because we understand that if there's 500 or more patients of yours, there's probably going to be at least 10 of those letters that get returned. You're not really going to know that maybe for years. So we are recommending that you provide substitute notice of the breach on your website. And that should be at the home page and the top of the page, and in your waiting rooms or other prominent location within your office. So again, in our handouts, we have that. Now, Change Healthcare is going above and beyond. Not only are they supplying the letters and providing identity theft protection, but if a patient feels that they've been harmed mentally, they even have set up a counseling number, and all this information is there. So we kind of took this information and try to steer them not from asking your office questions, but by going to the Change Healthcare resources to get updated information on that. Now, this substitute notice, you should put it on your website and in your lobby for 90 days, and you should have documentation. So document that it's on your website, take a picture of it in your waiting area so that you've got documentation there of that. So here's a copy of that. Again, it's in Word document, but we recommend that you put that again there. If you have an old one, we did have a first one before the update. Make sure that the release date on your notice of data breach is June 24th, 2024, so that you are making sure that the latest information is up there. This is a great time, as Joe told you, next week, or we're going to actually change it to Wednesday of next week at noon. We are going to have a webinar on implementing the cybersecurity performance goals and the documentation through our insight risk analysis of that. So please make sure you catch it. If you can't attend, always make sure that you do one of two things. Either sign up for it so you'll get a copy of the recording, or go to our HIPAA TV YouTube channel, and you will, within 48 hours, we have these webinars posted up there for review as well. And these may be ones that you want to send to colleagues as well. Okay, so now we want to talk to you about keeping your doctor out of HIPAA jail. I'm going to change it back over to Joe, and he's going to talk to you about what's going on with the DOJ putting doctors in jail for HIPAA violations.
Thank you, Michael. So yes, it may seem a little crazy, but doctors are now going to jail or facing jail for HIPAA violations. Usually when we think of HIPAA violations, we think of fines, audits, government oversight, corrective action plans, all the sort. But now the consequences are upping the stakes. The Department of Justice has now entered the HIPAA arena, particularly two cases that we'll go over and kind of what are the main takeaways that we can bring back to our office. These really center around violations of minimum necessary. A quick reminder of what minimum necessary means is that when we are using, accessing, or disclosing patient information, we should only be doing it with the minimum amount of information that is needed, and that we should only be accessing information when we need to access it for our own patients. And we'll get into a little bit more about that. So again, doctors are facing jail time for HIPAA violations. So we want to keep your doctor out of HIPAA jail. So the two cases that we are going over are a doctor in Texas is facing charges because he illegally obtained patient information from hospitals that were not his patients. The short end of the story is that he was trying to whistleblow on a hospital for doing things that were technically illegal, but he committed a crime first by accessing these patients' information with no medical reason to access them. We need to remember that just because we have access does not mean we have the right to access. And that case right now is still being kind of sifted through, charges are being filed and everything like that. But the other case we want to go over is an Iowa doctor has pled guilty. So right now we are in the sentencing phase, and we'll go over what his potential problems will be. So he pled guilty to illegally or wrongfully obtaining IIHI. So with great access comes great responsibility. We are seeing much more access, whether it be the implementation of information blocking doing this, the expanded rights of the medical records release guidance, that basically you're going to get much more access to patient information through portals and other interfaces. And you will have access to labs, hospitals, and things like that. And you might be able to think, oh, now I can go into friends or family, do them a solid, maybe do them a favor, say, hey, their medical records department's being a little slow. Can you just go get those for me? And you might think, oh, there's no harm here. There's no foul here. But in reality, you could be facing big jail time. It's important to remember that with these hospitals, with these labs and interfaces, they have real-time monitoring systems. And if you go into any patients and download records that you are not supposed to be, then they are going to catch you almost immediately, call you, ask you, what was your reason for entering those records? And if you don't really have a reason for that, then you're going to run into some problems. And most likely they're going to be termination, charges filed like we've seen. And so we want to avoid that. Surrounding this issue is that in general, protecting patient privacy has never been more important. So as much as we have talked about making sure that we are protecting from outside threats, that we also still need to be careful of inside threats. And not even just, the word threat implies that people have malicious intent in order to steal these records. But sometimes, these doctors are doing it for, reasons that they think are appropriate. They think that they are just, saving some time by not going through the due process that they're supposed to. So we want to protect patients. We want to protect their records from outside threats. We want to protect them from inside threats, and we want to protect them from, more negligence or kind of just, thoughtless action of, oh, I'm just going to access records because I can, and it makes my life a lot easier for convenience sakes. So we talked about the Iowa doctor who is facing charges and has pled guilty, and he could be facing a possible maximum sentence of 5 years in jail, a $250,000 fine, and 3 years of supervised release. This could be a huge reputational damage to not just the doctor, but the clinic that they worked at, the hospital that they worked at. And what we're seeing is that reputational damage can be just as bad as all of these fines, because these fines are kind of one time. Reputational damage kind of lingers with you for quite a bit longer. So really what we want to emphasize is that doctors need to go through the right process to access medical records, whether they are, a family member, a friend, they think they're doing something, that is just convenient or a favor for somebody. But doctors need to be, doctors, staff, anybody in the office needs to be accessing records with the same due process as, a patient would. So unless they have real medical reason to access those records. So we got to remember the minimum necessary standard, and that violation of it could be the worst of any of the HIPAA rules. So thank you for attending our webinar. Both of mine and Michael's information are on the screen here. If you have any questions, our phone numbers and emails are above. Michael, you have anything to close it out?
Yeah, I'm kind of taking it back from you here, Joe. And so, yeah, I just want to see if there's any questions. Again, remind you that we've got another webinar on cybersecurity best practices next week on Wednesday. And I'm not seeing any questions coming through yet, or you put them in either questions or chat. Okay, give just another minute here, and then want to thank everybody for attending today. Hope you got some valuable information. And again, Even if you don't use the chat function or the question function here, if anything comes up, please don't hesitate to give us a call. If you're our client, we are working on updating all these policies and procedures and hoping to have everything completed within the next 7 to 10 days so that when we do your yearly risk analysis, we get you fully up to date as well. Thank you for attending today, and we hope to see you in the next webinar.
Thank you.
With HITECH Associates, a real person works with your practice to complete your HIPAA documentation. We are not selling a software program. We are your compliance partner. If you are interested in making sure your organization is protected before it is too late, please go to HIPAAcompliancekit.com, linked below, to learn more about our services. We offer a free, no obligation, 30-minute consultation with your practice, and we'll send you a compliance report card based on that call. Thank you for watching. If you learned something, please like the video and share this video with your colleagues. Subscribe today to stay up to date on all things HIPAA.